Good morning everyone. So today we are going to present on Companies Act 2016. First of all, we would like to explain about Section 261 on Auditor's Statement. Auditor's statement must be presented to the registrar relating the financial statement. Accounting records and other books are kept properly. Financial statement is audited in accordance to this Act. Auditor's opinion on its report about the financial statement is in accordance to auditing standards and the ability to meet its liability. Therefore, if somebody commit an offence, they are entitled to pay fine. Anyone who violates this section shall be liable to a fine less than Rm20,000, and if the offence continues, an additional fine less than Rm1,000 for each days of the conviction on the offence committed. The next section relating to this topic is Section 263, which is the qualification of the company's auditors.
Firstly, any person who wants to be a company auditor shall apply to Minister of Finance. Person refers as a chartered accountant as defined under Accountants Act 1967.
In addition, the person must own a good character and is competent to perform audit duties to be approved by the Minister upon payment of prescribed fee. Lastly, the Minister may assign his powers to any person or organization who is responsible for the registration of accountants in Malaysia. Hence, approval granted by the Minister under Section 263(2) may be subjected to limitations and may be revoked by the Minister at any time by service of notice of revocation on the approved person. The other qualification is approved company auditor shall be in force 2 years after date of issuance, including renewal of approval unless revoked by the Minister. Section 264. Disqualification of companies' auditors.
A person must not give permission to be appointed as an auditor for any company. Next, is acting as an auditor for any company. Plus, a person also cannot prepare any report for or on behalf of a company if he is not an approved company auditor. Then, he is indebted to the company by virtue of Section 7 amounting more than Rm25,000. Therefore, a person is disqualified for being an auditor if he is, or his spouse is, an officer of the company, a partner, employer or employee of an officer in the company, a partner or employee of an officer in the company, undischarged bankrupt within or outside Malaysia except with leave of court, convicted with any offence involving fraud or dishonesty punishable with imprisonment for 3 months or more. On top of that, a person who is a shareholder or his spouse is a shareholder of the corporation whose employee is an officer of the company is disqualified for being an auditor. Lastly, he is responsible for, or if he is the partner, employer or employee of a person responsible for the bookkeeping of the registered members or debenture holders of the company.
Section 266, 1(3) is the duties of auditor. Auditor of a company shall report to the members on the financial statements, company's accounting and other records relating to the financial statement, provided the reports are a. presented before the company at its annual general meeting, public company, b. circulated to its members, c. presented before the company at the meeting of members. The auditor state whether the financial statements prepared are, firstly, true and fair view of financial statement, secondly, company's affairs are in compliance with rules and regulations, and last one is in accordance to accounting standards.
If not, the auditors should give true and fair view on matters stated in financial statement. Next, state reasons for holding opinion, and finally give opinion if director gives particular quantified financial effect. The auditor shall form opinion on obtained information and explanations. Proper accounting and records are kept as required by Act. Whether the returns received from officers are acceptable. Procedures and methods used are appropriate. Powers of auditors.
Section 266, 4 until 7. First of all, auditors are entitled to a. access information and records at any time, B. Require information and explanation from any officer or auditor of the company. Besides, auditor of a holding company that requires consolidated financial statement has the rights to A. Access accounting and records including register of subsidiary. B. Require information related to affairs of subsidiary from officer of company. Section 267 Appointment of auditors for private company. Appoint auditor for each financial year. Board of Directors should appoint an auditor when there is new company, as late as 30 days before the submission of first financial statement and to fill in vacancy. Plus, member shall appoint an auditor the next following year and if the Board of Directors failed to appoint an auditor. Lastly, any directors of the company that go against this section is considered as breaching the law. Section 271. Appointment of auditors of public company. Board will appoint at each of accounting period. Subsection 1. Before annual meeting and vacancy of auditor will be filled. Subsection 2. Hold until conclusion. A. First annual meeting paragraph 2A or B. Next annual meeting paragraph 2B. Ordinary resolution appoint by members during annual meeting. If the company failed to appoint during annual meeting or failed to do so and if the board failed to appoint subsection 2.
Section 274 Fixing of auditors' remuneration. Remuneration appointed. A. Fixed by members of company by ordinary resolution. B. By board fixed if not fixed, by company. C. By registrar if not fixed, by company. In addition, remuneration inclusive of sums paid in respect of expenses and payment. Section 281 Resignation of auditors. 1. Give written notice. 2. Notice subsection 1 brings to an end after 22 days from date given in the notice. Section 282 Notice of resignation of auditor to registrar. 1. Company send notice to registrar within 7 days, before receive resignation notice. 2. Commit an offence if breach this section.
Section 283 Rights of resigning auditor of a public company. When an auditor about to resign in a public company, it should be with a statement of circumstances. The directors could conduct a general meeting for accepting the explanation. The company should A. The notice has been made due to the subsection 3. B. Every member should receive a copy of the statement. General meeting should be held for ATLEs during the 28 days from the date of the notice made under subsection 2. The notice with a reasonable length could be requested to its member. A. Before the meeting was held on auditor's requisition. B. Before the auditors resigned or proposed to fill the vacancy.
Section 276, Resolution to remove auditor from office. Auditor can be removed at any time. A. By any ways in general meeting. B. In accordance with Section 277. Due to respect of the auditor resignation, it should not be deprived the person removed of the compensation or damaged. Before the expiration of the auditor term, he should not be removed unless by resolution under this section.
Section 277 Special notice required for resolution to remove auditor from office. First and foremost, a copy of notice of the proposal of removing the auditor should be done immediately. Then, notice should be given to the auditor to be removed in the registrar. An auditor may make a representation within 7 days with a reasonable writing linked to everyone. The presentation could be read out in the meeting if the notice is not given to the members. A copy of representation is not needing to be read out at meeting if another person is unhappy. The court will satisfy the auditor by using this section to secure needless publicity.